Good afternoon and welcome to today's presentation, Collecting and Understanding Electronic Medical Records and Litigation. The information presented by the expert is not to be used as legal advice and does not indicate a working relationship with the expert. All materials obtained from this presentation are merely for educational purposes. It should not be used in a court of law since the expert's consent, i.e. a business relationship where she or he is hired for your particular case. In today's webinar, Cory will discuss description of an electronic medical record, types of EMR systems, potential for data manipulation, gaining access to EMR data, and illustrative court cases. To give you a little background about our presenter, Cory Hamma is the Director of Digital Forensics at Califorensics. He specializes in electronic medical records forensics, complex forensic capture, complex data presentation, and targeted large data set culling. Mr. Hamma represents law firms, state and local government, high-tech firms, aircraft manufacturers, financial institutions, and school districts. Cory has testified in multiple cases, which have been included investigation of forged electronic medical records, employee misconduct, sexual harassment, and many others. He also has extensive experience in computer and network forensics. Attendees who require passcode, the word for today is records. During the Q&A session, we ask that you enter this passcode into the Q&A widget for CLE reporting purposes. The Q&A is located to the left of your screen. Please remember that if you are applying for CLE credit, you must log onto your computer as yourself and stay for the full 60 minutes. You're also required to complete the survey at the end of the program. Please note that CLE credit cannot be given to those watching together on a single computer. Tomorrow morning, we will send out an email with a link to the archive recording of the webinar. The slides can be downloaded from the resource list located at the bottom of your screen. Thank you all for attending today, and Cory, the presentation is now turned over to you.
Thank you so much. It's great to be here today, and I hope to give you a lot of useful information in your cases. My mobile number is on this slide, and if you'd like, you can feel free to give me a call to ask about a case you might have and see if the information and skills that I have and techniques that I have would be helpful to you. We always offer a free consultation, and of course we partner with TASA, so all of our cases that we talk about will be handled through them. We're located in Sacramento, California. Is my headquarters of the main office, and we have locations in Southern California and Central Texas as well. You can see we do a lot of different types of digital forensics. We're a bit of a boutique firm where we have some customizations where we really focus on these target areas, but we really cover a lot of digital forensics. The firm has been in business for 17 years, and we handle all different types of data, definitely plaintiff, defense, or neutral. I've got a couple of plaintiff cases going on right now and a defense case as well. My history in electronic medical records goes back to when I was working as the IT director and security director at the California Cancer Registry. We did some significant research on electronic medical records, and that's when I learned quite a bit about these different systems, having interfaced with them to handle some evaluations of public programs to see if they were effective. So I've got quite a bit of experience with a lot of different types of systems, and oftentimes a case will roll by my desk that doesn't involve a system that I've seen before, and that's never a problem because these systems are very, very similar, and I'm familiar with all the inner workings of how they intend to operate. So this introduction slide, you know that medical records are stored in computer systems, but even if you work for a medical center or have worked for an insurance company and you've dealt with producing patient records, you may not be aware of everything that's related to the records that is stored in the computer, in the EMR system. My goal today is really to expand your knowledge on electronic medical records. You may also encounter in your litigation skilled nursing facility records that are part of elder abuse cases. These are very similar to what we see in electronic medical records, but not the same, but they all have similar challenges. So some of these things that you're seeing today can be applied to those types of elder abuse cases. So this is the agenda that you saw before. First, I'm just going to get into what constitutes an electronic medical record outside of what you've potentially seen, which is the printout. So let's delve right into that. there's two major types of data that are stored, and one of them is structured data. So that's something where you've got some constraints on the data entered. Maybe it's asking you to choose a drop-down box of the state or type in a zip code or the patient's name. But generally speaking, you should find the data where you're expecting to see it. So if it's, for example, if it's the patient's name, their address, their social security number, medical record number, those are all definitely structured data. Similarly, patient or visit dates and times, those are structured data. Now, unstructured data, that's when you've got paragraphs of data. So you might have notes, for example, or a huge source of unstructured data. The other fill-in, where somebody says, what is this person's problem, and they have to write in something as a fill-in. That would also be somewhat unstructured data. And you know from looking at printouts of these that they don't look like the old paper charts at all. In fact, people have gotten printouts of these medical record charts for maybe a handful of visits, and it goes into the thousands of pages. And it's not pretty. Sometimes you'll see one line of text on a page. And that makes it really hard to figure out if that whole printed copy is complete, because you've got this huge collection of data, and none of it's really obvious as to where it came from, and you may have difficulty following it. So this is some of the things you would find in an electronic medical record. History of patient visits, physician notes, surgical notes, procedures. Those are really common things you're going to find in medical records. And nurses' notes, those are also very common. You've got prescriptions and allergies, lab results. Sometimes these are scanned in, and sometimes they're taken directly from the lab. So they could look a little messy and like a scanned document or a fax document. So that can happen as well. Attached documents. These are also other common things you're going to find. Patient demographics, and is very common to find. It's going to be on what they call the face sheet. And these electronic or paper from another medical provider. So there's ways to export data from a system and send it to the patient's new physician. And that's all part of the government's plan to help streamline electronic medical records. This last item is the money, is this audit trail or audit log. And we're going to talk about that in the next slide in some detail. So this is really common now. It wasn't always common, so I still see old cases where there's some physicians using old systems that don't have a very good audit trail or audit log. But this is designed to show you exactly not just who edited what when, or who created what record when, but also to say who knew what when. So for example, in a case where maybe there's an emergency room visit and the doctor didn't actually look at what happened in the chart before the patient was released, and it turns out that they were released at the wrong time, they should have been kept longer, then that fact that the doctor didn't actually view it is there. So sometimes these include date and times. Depending upon how the report is generated, it may only include a date. But I will tell you that in these systems, it takes more effort to exclude time information than it does to just leave it in. So oftentimes the report may not show the time information, only the date, but there is date information available. And each of the people editing the record should have their own login by law. So the physician shouldn't be using the nurse's login, for example, to put in information. They should be logging in there with their own login, and that's part of the HIPAA law. I always recommend that people ask for this audit trail or audit log data. And if you are providing this data as part of a court case, if you don't want to waste your time as a defense attorney, I highly recommend including this audit trail information just to keep the whole case less expensive for your client. So this clinics that received funds for implementing EMR systems under these meaningful use guidelines, that was part of this, is that they got some kind of a kickback from the government for implementing an EMR system at their practice. And in return, they're told, okay, this system has to be implemented properly. You have to actually be entering the records into it. It has to be tracking the audit trail, which is key. Right, moving on to types of EMR systems. So this is another big topic. There's two major implementations. One of them is on-premise. So this is the computer is at the facility, or it's at one of the facilities in a chain. So this means that they typically will either have staff on site who manage this computer, which contains all the electronic medical records, or they may have a contracted company that comes in and helps them out with this. This is important because even though you may have a contracted company, the data still resides on a computer at the facility, which makes it a lot easier to get at from my standpoint of doing electronic medical record forensics, especially on the plaintiff side. The backups is another big thing, is that the backups are likely to be there on premise and much easier to get at. The other side of this coin is that if they have it on site, the facility likely has access to edit the EMR data without using the EMR software. So if you can imagine somebody being able to sort of reach behind the curtain and manipulate the data with very little tracking, not to say none, but very little tracking, that can occur. The flip side of this is cloud hosted. So that means that they are paying the company, let's just say Epic or Cerner, they're paying them to host the system at Epic or Cerner's own facility. So this produces its own set of challenges, because if you've got to go after the data and do more of a deep dive, as we'll describe later, it can be tricky because the data is maybe in another state or potentially another country even. It's tricky to get data out, and it's also difficult to depose the experts because the experts are working for all these different companies at the same time, and because this is essentially a contracted large service. All right. Now, every system has very similar qualities. All of the systems that I've worked with so far use this table organization thing. So these database tables, they look a lot like spreadsheets. If you're familiar with spreadsheets, they look like enormous spreadsheets, but they can contain all different types of data. So sometimes, for example, the patient table is going to contain a list of all the patients, as well as their electronic medical record number, which is oftentimes used potentially with another number to identify the patient in other tables. So if you looked at the RX table containing all their prescriptions, you would not see, for example, patient John Doe. You would see patient medical record number 1234567 up here then, and then you'd have to map that back using the patient table and say, oh, okay, 1234567 that goes to John Doe. The same goes for all of these tables. So these are just some examples. One of the more important tables is the user table and the permissions table. So the user is going to talk about all the employees of the facility who are allowed to access these medical records. And the permissions table is going to say what they can access. And I will tell you from the perspective of doing certain types of cases that's one of the first reports I run, is to figure out what kind of permissions does this user have in order to determine if I'm able to see all the information that's present on the system, or if some of it's being hidden from from me because the user account we're using doesn't have enough rights, doesn't have all the privileges that are necessary. All right, so this locking record mechanism, this is this kind of digital signature concept. So after the physician signs a record, the concept is that they put their signature on there and then it locks the record. It cannot be edited in the future. It can only be added to with an addendum. The concept is wonderful. Implementation varies wildly between system to system. So if you're talking about one of the bigger name systems like Epic or Cerner, for example, or even NextGen, they do a pretty good job of documenting how the signature is placed, and it's a very official process, whereas I've seen some things in ChartLogic, for example, where you can actually put a signature and you can put a date and time of the signature, but it didn't actually lock the record against future editing. So that's where you may have to go in a little deeper. I've seen it happen where they put a handwritten signature and date time on the printed page. So they had a little signature stamp in the program and they stuck it on there, and it actually did not mean that the record was locked for editing on that date. The physician was able to type that in themselves. The last one is really important. Not all parts of the patient record are signed. Now, for certain software, if you change anything, it depends upon how it's set up, but if you change anything, even a prescription, it's going to document that. It's going to say what it was before, it's going to say what it was afterwards, after the change, and who made the change. But many systems don't audit all changes. They focus really on those chart notes in terms of change prevention and locking. That's something to keep in mind when you're looking at something that might be a critical prescription or surgery that was prescribed or recommended, and finding out that maybe that was edited later and there wasn't any tracking on that. So these are differences between the EMR system. All the systems have different types of reports. They all try to do similar things. There's no official standardization on what the reports contain, but these reports might be, for example, the full, some of them have this full report, which is allegedly supposed to contain all of the information in the chart. It usually contains most of it, but there's always certain things that it's leaving out, whether it's on purpose or because they have not written a report to export that specific type of data. Now, things like chart notes and prescriptions and surgeries and so procedures, things like that, those are almost always included in one of these gigantic exports. But you'll find that who changed what when is not necessarily included, and audit trail is oftentimes excluded by default. The signature method, that's the way that they handle the digital signatures and locking of records, and that's done differently on a system-by-system basis. And sometimes they organize the data a little differently. This can vary from facility to facility. So imagine that you are working with a patient who is at a large facility, and they may have their own set of data that they collect, and they need a way to save that in a way that's relevant to their facility and the way they've been doing business. So they may have a specialized implementation involved, which is extra data that's not likely included on a standard report, for example. And of course, this audit trail contents, the way this data from the audit trail is presented in a printed form, this audit trail data varies wildly from implementation to implementation as to what kind of data is shown and how it's shown. And we'll talk a little bit more about the audit trail formatting in a bit. Now, this is where we get a little complicated. So data manipulation can occur. There's many different types of data manipulation, and it's really difficult to get into all the different ones. I will say that these are really common. I've seen the first one myself firsthand, and we won a case based off of that. The physician looks like they opened the record at the time of the visit, for example, but in fact they opened the record long after they were served. And that happens quite frequently. The second one I just saw last year, physician provides a printed document not present in the electronic medical record. So what they'll say is, oh, well, we had this printed document, but we didn't want to scan it into the system, so we put it in this paper record. Or they will say, well, I don't really like using the electronic system, so we did this write-up, we did this, we put in the electronic data, but then afterwards I thought of some other things, so I hand wrote them on a printout of the data, and then we put that in a paper file with the patient's, associated with the patient, and I, the physician, signed it on this date. Now, the interesting thing about that was when you print out from a web page, and I will tell you that some of these systems are web-based, so they use a web browser to access the electronic medical record. If you use the web browser itself, like Google Chrome, Microsoft Internet Explorer, Firefox, Safari, if you use one of those, the printing, so you tell the web browser, you go to the file print or whatever print menu, Control P, something like that, then it is the web browser that puts the date on the record, not the EMR software. So the web browser puts the printed date on there. I can change the date on my computer, basically backdating this record. So I pull up the record, I change the date on my computer to the date I want it to show, I hit the print key. So when we see this happen, you usually notice it because the web URL or web link is printed on the bottom left of the page. That's how it signals that this type of printing was done. When you see that, then you should not be trusting the date that appears in the bottom right corner of the page. It could be obfuscated. It could have been falsified. There's really no good way to tell. Within the software itself, there is a print feature. And the other thing to remember is the print feature is oftentimes included in the audit trail. So you can tell when somebody printed the record. That gives you, oh, okay, that makes sense. I've got a printed record here. I have a record printed date as part of this record, and I'm going to, and I can assume that that's accurate because it doesn't have a web link at the bottom, and the audit trail lines up and says they printed it on this date. So the last one happens oftentimes in nursing home cases where something happened to a patient and the staff realizes that they should have been checking on the patient and they didn't. And they'll try to go back and put in a bunch of records indicating they checked on the patient was fine. They freak out that they died from something that was preventable, and they try to cover it up. And some systems will be really obvious, and they'll show you in red that this was a backdated, note. And sometimes they won't. So it really depends upon the type of system. If you're trying to look at backdated information as part of a nursing home case. All right, so entries removed. So I will tell you this, the reason why I bring up entries removed is that it's similar to many other electronic pieces of information, way information is stored, and that when you're programming the software, when you're writing the software, you have a choice of what to do. When somebody wants to delete something, do you actually purge it from the system, or do you simply mark the item as deleted, which will prevent it from being shown to the user when they're looking at the screen? So the second way is the most common. It's time-consuming to remove and purge something, and they don't want to hold up the system. The data itself, saying, oh, I'm worried about running out of data. Well, the amount of data used is negligible. It's tiny. So what they typically will do is mark something as deleted and move on. I oftentimes find that there's maybe some note in there that they realize afterwards, we should not have put that in there. They will delete the note, and then it's deleted from the record, and it's not necessarily reported that it's been deleted, but it's still present within the system. Billing data is another big one. I find that people often overlook billing data when dealing with cases. That can be a red herring. So if somebody has put in charges but then removed them, like we're going to pretend that this didn't actually happen, that is also a big red flag. And so billing data is just as important as the medical record itself in certain cases. Sometimes the billing system is also completely separate from the medical record system, although that's becoming less and less true since it's inconvenient to do it that way. All right, we're at our first Q&A.
Thank you, Cory. If all the attendees can enter in the passcode for today, which is records, or any questions that you have. Our first question, I keep getting told that a HIPAA form I use is not accepted by medical provider, and then I have to resend their particular form. Isn't there a standardized form under the law?
That is a really good question, and I do not know the answer to that because I'm often not using a standardized form to gain access the data. There is a standardized business associates agreement which is used to gain access to medical records, and we can talk about that in a little bit. And that's typically what I'm using when I'm trying to counteract the fact that they'll say, I can't let you see these medical records because they pertain to another patient. They could have data pertaining to another patient.
Next question, and I'll push this to the slide. The hospital often decides what data is included in the official chart. Sometimes things are left out, such as correspondence. That used to happen with paper charts also. How do you make sure you have all the data in the EMR system? That's
a great question. And I'm going to talk about this in the second part of this, but essentially, when I'm working with people who either have gotten multiple versions of a medical record, some more inclusive, some less inclusive, what I like to do is actually perform my own exports of the data through an inspection process. And in that case, I can run the reports and completely inclusively of all the data. That being said, not all of the data is included on the report. So as much as you may want to get the data in that convenient manner, sometimes it's necessary to do what is essentially a video walkthrough of the medical record, recording the screen to get the full record itself, especially when there's like one particular date that's in question, one particularly sensitive date. Great question.
Next question. Is there a difference between asking for the medical records versus the complete legal medical record?
Is there a difference? Well, no. It's really squidgy on this. It really depends highly on the software involved. The providers of the software, let's just say Epic, Cerner, they make the choice of what reports to produce. So, and the reports that get produced are typically available on all of their clients, all these medical associations. All of them will have a similar set of base reports, but then each facility can also write their own reports if they've got a nice robust system like Epic, for example. So there's no standard for any of this, unfortunately, yet to give a standard legal medical record, including that audit trail, is highly contested in many cases. So yeah, that's a great question. Thank you.
Next question. If you want to dispose a person in the hospital who can best answer questions about how the record is formulated and how to get data that's not in the official chart, what person should you ask for?
Yes, that's also a great question. The person I ask for is the medical records administrator. They may or may not have somebody who has that job title. The other thing I would ask for is if they've got an IT department, let's say this is a larger organization, they're going to have a director of IT. They're generally responsible for the system, even though they may not be the person who works on it on a day-to-day basis. So the PMQ, the person most qualified, is sometimes not the director, but maybe like electronic medical record systems manager. Or if you're getting deeper into things, I end up myself working with the database administrator, but that's not something that I would expect an attorney to be able to interface with, because the kinds of questions you need to ask them are a lot more technical than you're used to. But I would go for the electronic medical records administrator in this case.
Next question. Have you worked a case where an anti-forensics program was used to wipe data? Is that data retrievable in any way, and does the audit log show this wiping has occurred?
So that's a great question. We have worked a number of cases where anti-forensics programs were used. We get a couple of things out of this. One is that we can detect if they were used because there's almost always log entries showing when they're used. And the other part is the data retrievable in any way? So the answer is sometimes. It depends upon how long it has been since this data was wiped, because it's often stored in multiple places on the system. So there's sort of hidden areas on the computer's hard drive storage device, which is trying to store copies of things that it thinks are important and you might really care about if they were to go missing or corrupt. And so we can pull stuff out of that. The other thing is backups. So going back in time to previous backups is a great way to find old data. And I find it to be a great way to see maybe what a previous version of something was before they signed the records. Imagine the doctor editing a record, editing, and then signing it. Wouldn't you love to see what that first day of edits looked like? So that's something that would be captured in a backup. Good question.
Next question, how do you maintain EMR while a procedure is being done?
Right, so how do you have to maintain EMR? So I'm guessing that this is, let's say I'm working on the system. None of this work that I do when I'm inspecting a record prevents the system from operating. So there's no actual outage involved in this. The other thing that people ask me about is how do I maintain the security of the data, the patient data specifically, and I have that CISSP certification, plus I've got 11 years of experience securing electronic medical records for a cancer registry. So I know all about securing medical records and using the appropriate encryption and controls to ensure that all the HIPAA requirements are being satisfied and the patient data doesn't get leaked. Great question.
Next question. I contract with attorneys as a CLNC, so I see both sides. What about asking for incident reports and shift change reports that are sometimes taped?
Yes, we see that a lot, especially when it comes to nursing homes. They have these 24-hour reports which contain data on multiple patients. So I can talk about this a little bit later, but I'm going to use this as a point to bring it up. We have this thing we call a triangle agreement, which allows me to go and inspect something. And let's just say that you're working for the plaintiff. It would allow me to go inspect this report, redact the stuff that's not related to the patient, and then produce it to the defense attorney, who can then review it and produce through normal discovery to the plaintiff. So that's an agreement we often have in place when the plaintiff is willing to pay for our services, and the defense attorney is very reluctant about allowing me into the medical record because they need to be able to see things before they go to the opposing side. So that happens all the time. Go ahead.
Okay, I'm sorry. You can continue.
No, I'm good. That's great.
Oh, next question. Okay. Our last question for this section is, the physician emails to a staff person and attaches a document. The staff person opens it a few months later and changes the date on the attachment. Assume also that the staff person physician destroy the browser, i.e. Firefox, to open the email. Is there some way to determine when the staff person actually received the attachment and when the physician actually emailed the attachment to the staff person to refute the date of the attachment? And this is on the
that is a really detailed question, boy. So yeah, we encounter things like this all the time in digital forensics. This is not strictly EMR forensics, but we encounter that. Now, when you open an attachment, it saves it into a temporary file on the computer. So that's where I would go first. You can't just open a file from a link on a web browser. It has to be saved somewhere. Whether or not it saves that attachment file that was downloaded is a good question. Or how long it saves it for is a good question. It depends upon the software in the computer. But yeah, there's definitely options in that case to get a better timeline as to when that when the physician emailed the attachment and when the staff person opened the attachment. A good question. Thank you.
Thanks, Cory. You can continue with the presentation.
Great. All right. So gaining access to EMR data. This is the biggest question I receive by far when I present, is talking about how do I get access to this data, especially as a plaintiff's attorney. So the first thing I ask for is native format. If they've taken those PDF files and they've scanned them and then that's just a mess. I would ask for everything in native format. So oftentimes that's PDF. Sometimes they're able to export the medical record in what's called XML format. That's usually used for transferring the record to another facility. I'm not saying that that's a great format for you to get because you can read it. I'm saying that's a great format for you to get because I can read it, although it usually does not contain the best information like an audit trail. I always ask for the audit trail audit log with the electronic medical record as a matter of course, as there's a case right there saying the chart is not complete without the audit trail and audit log. There's a lot of arguments back and forth, but it's pretty much going the way of producing the audit trail or audit log whenever an EMR is requested. So this reason why you need to delve further is when you think that there's been some funny business with this medical record and you're really looking to see if somebody has modified something potentially illegally. So oftentimes we look at multiple versions being sent of the same thing, of the same report, for example, and they seem to contain different data in the same report. So that's oftentimes what's asked. Another reason is if the audit trail is claimed to not exist, that can be a huge one where they say, we just do not have it, we'd upgraded the system and it just isn't there. That's another great reason to delve further into it and try to find places where either we can manually export an audit trail or find database backups which would help us tell the picture of what happened when. So this is the first part I recommend to attorneys is this walkthrough of the patient's medical record. You can use a court reporter and videographer, and sometimes they choose to do that, but I will tell you that I typically use software instead of a videographer because the quality of the output is so much better than a videographer capturing the screen using a video camera. So I walk through the chart, and sometimes I'll walk through the entire thing front to back, every possible place data could be stored because the attorney wants to obfuscate what they're really looking for. They don't want to give up their plan at this stage. It's important, though, for you to disclose some strategy with an EMR forensics expert because if you're just telling me go through the record, it can take a while. I've had these take more than one day to go through if this person has been hospitalized or in a facility for any significant amount of time, depending upon the system. Some systems are much quicker to go through and some hide things. One of the things that this allows you to do is occasionally you'll have this hover situation where additional data is viewable if you hover your mouse cursor on an item on the screen. There's a little pop-up that occurs. So this video walkthrough will capture those pop-ups, which likely don't appear in reports. It's also really useful to show, oh, look, if you go look at it one way or through one report, you get one answer. And if you look at through another report, you get different information. That's a great way to get to kind of the next phase if you need to go for the deeper dive. So the deep dive I find is really helpful when either the system is not capable of producing the data, maybe the system is no longer in service, it's an old system and all they have is a backup and you need to get into that backup. This is how you do it, is through this deep dive. Or potentially if you suspect that the system is not showing you all the information, like the patient is saying one thing and the medical record is saying something completely different. And you think, well, I bet there's some way that this is documented, how it got from what really happened, or hopefully the patient's being honest, to what is reported by the physician. So sometimes, like we had a problem with date and time stamps only showing the date and not the time. The history of record changes. Now we've had an issue where those, when they change things, when you get the audit trail report, it doesn't actually have any kind of like serial number on each document. So there's no way to truly identify which chart note was edited. It's just a chart note was edited, especially if more than one note was created on a day. There'd be no way to tell which one. Now, I'll tell you right now that the system keeps that information. It may not be showing it to you, but that detail of exactly what document was edited when, or what portion of the record was edited when, is stored in the system, even if it's not being reported to you that accurately. Of course, if the audit trail is completely missing, your options are more limited, but this is also a great way to go after that type of situation. And then record closing and opening dates and times. That's, when they click on it and open it versus, they log off and close the record. Those may or may not be registered in the audit trail, but they may be registered in a different portion of the system, such as a database log. So a lot of what we're talking about here in this deep dive has to be gathered directly from the database itself, and it requires somebody who knows about electronic medical records and databases and database forensics to capture effectively. So the best thing you can do when you suspect something is there and you need to go deeper and you need to have ammunition in order to justify going deeper is to figure out what exactly is not presented. So you've got your list of items and which ones contain the suspected falsifications and why we suspect they contain these. Now, for an on-site system where the computer is at the medical facility or at one of the medical facility's offices, then it's a lot easier to get the system data from the medical facility. I typically recommend that the data is exported. They may claim that it's an undue burden to export this data, and in some sort of what they see as the proper format. The beauty of working with me is that I can accept almost any format that they produce it in raw, no extra work required. So this excuse of, oh, it's so much extra burden. No, just dump the data to a drive that's encrypted, hand it to me, I'll take it from there. This BAA is really common for using when they say, oh, it's a HIPAA violation, we can't possibly allow you to view those. And then the triangle agreement, what I mentioned before, comes across where they say, well, the attorney can't see all of this data. The attorney should only be able to see the data related to their patient. And I agree. That other patient data unrelated is not the plaintiff's business. And that's why the triangle agreement is really helpful to say, well, everything that I, as an expert, am going to produce will go directly to the defense attorney, who can then review and produce through normal discovery to the plaintiff, including a report. Now, this cloud-hosted system is very similar, but there's this added hiccup of the data may be in another state. It may be in another country even. So this is a very tricky thing to collect. And the thing you want to remember when you're dealing with this data is that it's kind of a hot potato. You don't want to have it in your hands. It's raw electronic data that it should be encrypted at all times. You may not have the facility and IT experience to make sure that you're treating this data with the appropriate controls. So having an expert is really helpful. And also, I'm oftentimes asked to help write up the subpoena, describe exactly what I'm going to do, what the data contains, and put in any notations for the BAA to get this out. When I've encountered this, oftentimes the most difficult part of this particular deep dive process is actually the company itself. So not Epic, but that wasn't the case with Epic, but let's just say Epic, very, very concerned that the data that they're exporting goes to somebody who knows how to deal with medical record data, and they're not just handing it to some attorney who may not know the appropriate security requirements, stuff like that. Or they don't want to be answering questions from me about that. So the other thing I might point out is, whether you're doing a shallow or a deep dive, the first thing I tell people is ask for the user and administrative manual and any training manuals that the people have received. Because if it comes down to who was told how to do what, and they're not doing things according to their own manuals, that's one thing. Another thing is, I often refer to the manuals, and these are ones that you typically have to get from the facility. So I'll often refer to these manuals to say, this is how the data is stored according to page 873. You can see that it's stored in this manner, and that's why I'm able to make these statements about the data. All right, so we've got some illustrative court cases. A lot of these are about actually getting access to the audit trail because that can be very challenging depending upon the defendant. So in this case, they were claiming that, the defense was claiming that the plaintiff has to show that the records produced were not authentic before being entitled to receive the audit trail, but the plaintiff successfully argued that the audit trail is part of the medical record because it describes what happened in the medical record and how it was modified and viewed, who knew what when, and the court found in favor of the plaintiff. This Moan v. Mass, now in this case, there was a peer review committee that was looking in the medical record, so it really doesn't matter who's looking at the chart. It's going to record the access. And they said, well, we really don't want to share with you who was on the peer review committee and who reviewed these. We'd like to leave those out. And they were allowed to leave those out, those particular records out of the audit trail. In Hall v. Flannery, they were asked to produce the complete audit trail and all the peer review access and the actions taken by risk management. In the Hall v. Flannery one, they claimed that the audit trail is not created in anticipation of litigation, so it does not imply core attorney work products. They were able to successfully argue that the audit trail should be considered in its entirety, including the peer review access, and does not include mental impressions and conclusions, etc. You know this, you're attorneys, many of you. All right, that's Green v. Pennsylvania Hospital. This is the case of, if you're going to hire an expert to work on these, they better know about electronic medical records. They better know how to deal with the data security associated with medical records. Even if the patient is deceased, you're still required to maintain HIPAA on that HIPAA security on that data, which means secure encryption on that data for 50 years after their death. So keep that in mind. No emailing around deceased medical records just because they're deceased. And this last one, getting close to the last one, this Myers v. Riverside, this activity by medical record, it didn't include the underlying medical metadata. And there's this argument about the plaintiff wanting the information on a USB drive, and the defendant offered a computer terminal at the facility to view the information. I find this case really funny because I would have chosen the computer terminal over a USB drive any day of the week. Let me in there, let me look at the stuff. Now, maybe the attorney felt really uncomfortable about looking at the data, especially when you consider that if the attorney is collecting the data, then they themselves have become a custodian, which might exclude them from being part of the counsel. They might have to bring in new counsel if they're collecting their own data. So if they'd reached out to somebody who knows electronic medical record forensics, that would have been really helpful to them to just send that person in to get the data from the computer terminal, probably recording the screen the whole time, and potentially getting a lot more information than the facility was originally going to provide to them. All right, this is a great example. 4 different versions of the printed EMR were provided. And the firms that I've worked with in the past have seen this kind of thing all the time. And that's a great ammunition for saying, give me that audit trail. I want to look at this record from the perspective of an in-person inspection by an expert, because we're getting all kinds of information here and I can't tell what's accurate and what's not. So this one was tricky because at the time, this is a 2016 case, but it referred to obviously data much earlier, because in the early versions of this Cerner software, the audit trail was an optional feature which the facility didn't purchase until after this event, which caused this lawsuit. So it can't produce an audit trail. It does not exist because the feature wasn't enabled on the system. And they, at that time, weren't required to have that feature. And finally, this one's interesting because the patient was required to sign a document, but there's some contention about that. They were not able to produce a digitally signed document. They may have checked a box in the system saying that the person signed the document, as far as I'm concerned, from a forensics perspective, anybody could have checked that box at any time. And it doesn't necessarily mean that there was a signature. If you're not capturing a signature and that's not something that's shown in the audit trail, that's really not that's not a good situation to be in for a defendant. So they were granted production of the electronic audit trail, which probably did not indicate when and if they signed this thing. So that's it for my presentation, and I've got a little bit of time for some more questions.
Thank you, Cory. If all the attendees can enter in the passcode for today, which is records, or any questions that you have. Our first question, if we request all audit trail data in Discovery, don't we have to have the EMR software to view it? Would the application be provided with the data?
That's a great question. The audit trail data appears as a report. So if you're asking for it in Discovery, they should be giving you a PDF report, which would look like a table. So that's a great question, and you don't need any special software to view it.
Next question. Do you have a suggested wording for a notice to produce to get the complete records?
Right. So you can try to get the complete records, but there's nothing that is necessarily going to give you the complete records. They may not even know how to give you the complete records. That's the truth of the matter. So I recommend reaching out to an expert who knows how to get those records, especially if the case warrants it, if it's an amount that warrants bringing on an expert, because it's not something that you can just say, do it, and they magically will produce them. There's no way for them to even be 100% certain that they're producing all the records without an expert.
Next question. Are there universally accepted standards protocols for hospitals to maintain data? If so, does the expert have a link or name or organization that maintains such standards?
So no, there's no standard for retaining data. What I would say is ask the hospital for their data retention policy. So that's going to talk about when they back up data, how long they keep those backups for, and when they destroy them, what their destruction process is. So oftentimes we find that they keep data for a long time, and occasionally we find that they have no backups at all, and that's usually when you're talking about a small clinic. Thank you.
Next question. Do you need to come to the medical facility in person to do an inspection, or can you do that remotely?
And that's a good question. I got asked that just last month, and while I would love to do it remotely, there's a couple of things that come up with. One is that the software that you use to do the remote inspection, the screen sharing software, is not HIPAA compliant. So I can't do that because it's not HIPAA compliant. It also gives them ammunition to say, we're not okay with that because it wouldn't maintain HIPAA compliance. It potentially could be viewed in transit by whoever is, like Zoom or GoToMeeting or something like that. So it is best to do it in person. Plus, if I have to point to somewhere on the screen, even if I did have the right software that was HIPAA compliant, oftentimes it's difficult working with the people who are controlling the system, the employee at the facility, and you need to be able to point to something physically and say, click there. Thank you. Good question.
Next question. How do you document a medical procedure in EMR?
So medical procedures in an electronic medical record are documented typically through a chart, through a surgical note. So the surgeon is going to, oftentimes we find the surgeon is going to dictate something, and then that dictation becomes converted into text, and then they review the text portion of it to confirm that it matches what they remember from the dictation, and then they sign it digitally. That's typically how the process works for a surgical record. Next question.
Next question. Is a request for the audit trail audit log the best solution to counter suspected spoliation of medical records or evidence?
Absolutely. That is the best first step to counter that claim. So I would do that first. Great plan.
Next question. For the shallow dive, I'm still not sure what a walkthrough of the EMR consists of. Do you have to be on the premises and logged into the chart to do a walkthrough? Can you explain the logistics a little?
Absolutely. So this walkthrough, if you imagine that if they'll let me, I will sit down at the computer and they'll typically have the computer logged in already to the chart itself, and then I'll go through all the different pages in the chart, click on all the links that are there, look at all the places where data is stored, whether it's chart notes, prescriptions, stuff like that. I'm also going to grab the audit trail while I'm at it pertaining to that patient, and pretty much anything that possible that pertains to that patient. And then we negotiate, or I should say you negotiate, or the attorney negotiates as to what kind of, if it's a plaintiff's attorney, what kind of access is going to be given to things like maybe a 24-hour report or a shift report that might contain additional information about the patient but wasn't included as part of the medical record because it contains other patients' data. So that's a great question. Yeah, but it's done in person. And I record the screen. So just one little thing, I record the screen so that I can produce these screenshots, really clear screenshots of anything you happen to see at any moment, whether that's a pop-up or something else. That makes the whole process very, very efficient because I don't have to stop and take screenshots every time you see something interesting. Okay.
Next question. Are all medical staff who worked on the patient told about this search by this time?
So typically we try to do the depositions first, and especially if it's a plaintiff's type situation, you're doing the depositions first of the people who might have been involved in the medical record, and that's because the plaintiff's attorney is trying to catch them saying something that might be inaccurate about the medical record, and then do the inspection afterwards so you can confirm or deny what it was these people said in their depositions. Great question.
Next question. I apologize. I did not understand if attorney is entitled to shift change notes in incident reports.
So I would say that the attorney is entitled to them, but only a redacted version which contains just their patient's information. So for example, if 4, 5, 10, 12 patients are included in a shift change or incident report, incident reports, that's a sticky situation, and there's no clear delineation on that. That's the worst one. The shift change, yes, that does contain information about a patient and their state at a particular change of shift. So if it's not appearing in the patient medical record, you can go after those, and your mileage may vary. Incident reports, you're unlikely to get them, but you can always try. Good question.
Next question. What is it meant by native format using Epic A, an example?
Okay, so using Epic as an example, native format, when they produce these reports, they're typically in PDF format. So you're saying, give it to me in the PDF that you could export from the system. Now, they may say, well, it gave us a print option. And I would say, well, then print it to PDF. Don't print it to paper and then scan it, because then it's a lot more difficult to search for things. Just do a print to PDF and save that PDF if it doesn't have a PDF export capability. Some things you're going to say, well, if it has like an Excel format, can I get Excel instead of PDF? And that's done because sometimes you'll have text that exceeds the width of the column, and it gets chopped off, but you'd like to see what it looks like. So this Excel format, if it's available, would be the preferable format, because it's going to be the most searchable, the most easily sorted when you're looking for particular date information, and it will also not cut off the text typically, like a PDF would. Good question.
Next question. Is this information metadata?
So some of the information is metadata. So metadata is data that describes other data. So some of the information that's collected is metadata. For example, if I'm trying to find out, for example, for a nursing home, they might have some observations that were collected, then were used to make a final decision about the status of the patient, like were they able to use the bathroom by themselves. So is it metadata? Technically, no. All of the data is data. The metadata comes into play when, let's just say that you're going after a piece of paper that was allegedly faxed over, and you're trying to figure out if it was modified or pages were removed at some point, and we're looking at that file itself on their server to say, okay, when was this file last modified? Was there any evidence that this was modified? Then we're looking at metadata in that context. Good question.
And our last question, what if the attorney sends in a legal assistant for the search? Is this acceptable?
You can send a legal assistant in for the search. The challenge is if the legal assistant is not versed in electronic medical records, that's a great reason for the facility to deny them access, because if they're not HIPAA trained and if they don't have any kind of certification in data security, that'd be a great reason to turn them away and say, no, we're not going to let you in to do this. You may be a legal assistant, but you're not familiar. And that's one of the things that the examples that we gave at the very end was, if the person is not properly skilled in medical records, so if they don't have the data training, the data security training, and the medical record software training and experience, then they may not be, that's a good reason to not allow them in.
Thank you, Cory. Please remember that if you are applying for CLE credit, you must have attended for the full 60 minutes of this presentation. You're also required to complete the survey at the end of the program. Please note that you will be receiving your certificates via email in 24 to 48 hours. I want to take this opportunity to thank everyone for attending, and most especially Cory Hamma for his time and effort in creating this presentation. If you would like to speak with Cory, if you would like to speak with a TASA representative regarding an expert witness for a case you are working on, please contact TASA at 1-800-523-2319. One of my colleagues will be following up with you regarding your feedback on today's presentation. Again, thank you all for attending. This concludes our program for today.